I am representing the University of Nicolaus Copernicus from Toruń, but also Polish Society for Legal History, a young organization established a year ago to help our community. And in the beginning, I owe you a few remarks on legal education in Poland in general. I called it right here an attempt at diagnosis, but obviously I won't be able to talk about it in detail. I will just present you with some crucial issues. First of all, Polish legal education is still strongly rooted in legal positivism. Most of the curriculum focuses on so-called dogmatic courses. You know the drill: civil code, criminal law, administrative law, tax law, and procedures. Obviously, it is focused on Polish law. Foreign law is marginally mentioned. And students are presented with legal provisions from various statutes and codes. And they memorize mostly semantic meaning of words, and they learn about established theses from judgments of higher courts, and skills in interpretation of law are limited just to rules of traditional formal logic. And the knowledge is served to the students by lecturers mostly without this larger context of social, economic, psychological, political, or technological context. And obviously, I do not try to argue that there are no other influences or other ideas. There are wonderful stuff going on in Polish legal education, but the trend is visible. We are still in this legal positivist paradigm. And it won't change probably in the near future, maybe in further future. The Polish curriculum obviously includes a set of non-dogmatic courses supporting this idea of general legal education. Their role, however, is strictly limited. Polish law students get small courses in economy, sociology, new technologies, and obviously legal history, but without precise vision of their purpose. These courses are put into curriculum mainly during the first year, and they are seen as simply this small introduction to proper legal studies. In the eyes of many, they are just useless, and they should be eliminated because they unnecessarily prolong the duration of university legal education. The important thing is legal history and those other context subjects are not crucial for legal education as a whole. And in these circumstances, the vast majority of my colleagues, legal historians from Poland, tend to see courses and classes on legal history as this relevant, even crucial remedy for this domination of legal positivism in legal education. Here it is, a small quotation from one of our most important figures, Professor Witold Wołodkiewicz. It is a long quotation. I will just show you this small part. The lawyer as a humanist should keep a perspective towards the law as a cultural, social, and historical phenomenon. General and context courses should give the lawyer a distance from the law, its purposes, and changes. This is something that we've heard a minute ago from Professor Viviana Kluger. This is exactly this attitude, and this quotation and this attitude is obviously beautiful, but we have to understand that there are a few problems with this attitude. Firstly, my fellow legal historians always argue against this idea of more practical approach to legal education. The problem is this is not our decision. This is not our choice. Legal education is and always will be connected to the market, and it needs to answer the needs of this market. So for 3 decades now, Polish lawyers, scholars and practitioners have tried to rethink how to teach young people, young lawyers, according to dynamic changes in our world. And in the presentation, I can show you, I won't be able to probably to read it to you, but this is this small quotation that show us perspectives and influence on legal education by development of new technologies. And obviously other predictions are out there. Some of them are more possible, some of them are less, but this is this great discussion about how we should teach young lawyers in this present day reality. And unfortunately, legal historians do not even want to talk about it. And by refusing even to consider the students and graduates' practical goals and needs, we, our community, we legal historians, exclude ourselves from this broad discussion. And this is a shame, this is a problem, because there are decisions on the curriculum that we don't take part of. Second problem with legal history in Poland is that our courses are divided into various separate and unrelated classes without coherent purposes and ideas. You have to know that we are not determined enough to innovate programs, and we are not determined enough to include in our courses relevant issues. For example, during this conference, we've heard so much great things, great ideas about how to teach about colonialism, or for that matter, space law, history of space law. And there is no such broad discussion in Poland. Obviously, there are a few interesting ideas. During the previous session, Łukasz Korporowicz showed us some ideas about teaching English law and American law, history of English law and American law to the Polish and foreign students that are studying in Poland. But most of the time, our curriculum is completely outdated. And the third issue is that our teaching methods are also outdated. Polish legal history courses mainly focus on detailed facts about historical legal sources. Students are forced to memorize complicated technological knowledge, actually mindlessly, about the code names and dates and biographies of creators of the codes and other details, for example, how many articles and chapters one code had. So the contents of those codes are characterized without enough special social, political, ideological, economical background or context. Also issues of practical implementations of legal provisions are marginalized or even non-existent. So students must live through really boring classes, memorizing mechanically theoretical knowledge from overloaded educational materials, and after that pass difficult and detailed exams. This is not encouraging to be interested in legal history. And fourthly, you have to know that Polish handbooks on legal history are mostly compendiums of those boring facts, and this is really a problem of attitude. But fourth problem is really crucial. Let's assume for a moment, it's easy for you because you're not from Poland, so let's assume for a moment that we believe in this beautiful fairy tale, that legal history in Poland, in current state of affairs, is really capable of teaching students about social, political and cultural repercussions of implementing legal provisions, or that imagine that legal history can really help young people to understand mutual influences between the law and social reality in history. In this situation, in this case, we should really ask ourselves we should really ask ourselves, are legal history courses and classes actually the best way of talking about those issues? Aren't sociologists or specialists of political science or economists or philosophers more qualified to achieve those goals and to talk about those issues? This is really relevant question, and I will tell you why. This is really interesting how Polish lawyers want to reform our Polish legal education. There are obviously the American direction, Socratic method and so on, maybe more clinical education, but this is not exactly popular. Much more possible is another direction that I really like to call binary legal education or bipolar legal education. This is the legal education that will consist of two harmonized, more or less equal ideas, segments. The first of them will be set of classic dogmatic legal classes, and the second will focus on surrounding worlds, about surrounding world, by teaching sociology, economy, philosophy, psychology, new technologies, art of negotiation, rhetoric, skill of management, and so on. And few of my colleagues see in those probable changes the chance for legal history, but other lawyers see this issue differently. This is small quotation from one of the most interesting papers on reforming Polish legal curriculum. And Małgorzata Chmura wrote this really interesting sentence that those changes are possible to implement into the curriculum without unnecessarily prolonging the legal studies duration by reducing the historical perspective and courses on Roman law, legal history and classical philosophy, as well as by limiting hours devoted to dogmatic legal subjects. So this is not the unique opinion. This is common view from my lawyer colleagues. They don't think that we should keep this positivist legal education. They think we should change it, but they do not see legal history as a chance for it, as a great option for this change. They rather see it as this schedule filler that is blocking those changes. And in the end, because probably my time is almost over, I want to say few things about what we should do about this situation. And obviously, as you can see, I am a little bit overcritical. Maybe I am a little bit unfair, but I want to just show you the main problems. I don't want to highlight our achievements. I want to just try to show you our problematic spheres. So, first of all, Polish Society for Legal History attempts to establish the actual position and attitude of Polish legal historians toward the present-day state of education. We prepared this survey form with questions to our colleagues. We now sending it, and we hope that before the summer we will get answers, and in the autumn we will have a full report on current status of Polish legal history in education. And we hope that we will see what is real attitude and maybe what legal historians think on the future of our subjects and our courses. Secondly, there is a pressing need to establish some kind of database with educational materials. This is the problem for young legal historians, that they don't have enough materials and ideas and lesson scripts, screenplays and so on to do legal history differently. So we want to help them, and we will want to create this database with exercises, with sources to help them to prepare for more engaging legal education. Third of all, it is my personal dream. I hope that we will able to establish this online school for legal history with outside legal faculties to do lessons online, to experiment with many great ideas. During this conference, I've heard a few. For example, there was this great panel on global legal history. It's so interesting, and we could do those lessons online without restriction from our faculties. And I think that this is a great idea and great chance for us to figure out what we should do. And maybe that's all. Maybe just one last thing, that we really should fight with our faculties to have lessons and classes for more advanced students. It is really hard to explain proper legal history for students, for pure beginners. So we need the chance to address our knowledge and our experiences to more advanced students. So thank you very much.